Should Donald Trump be allowed to run for president of the United States? That's the core question the U.S. Supreme Court waded into today. And there were some moments.
But ultimately, what we have here is an insurrection that was incited in plain sight.
Yeah, you're really not answering my question. It's not helpful if you don't do that.
9 Supreme Court justices, 6 conservative, 3 liberal, were hearing oral arguments in a case over whether Colorado's Supreme Court got it right when it removed Donald Trump from the Republican primary ballot, slated for next month. A decision at this highest court would have a huge impact, not just on the vote in Colorado, but across many other states that have tried to disqualify Trump from running for office on the grounds that he is an insurrectionist. So let's get to the arguments. Over time, we've seen a big shift in the arguments that Trump's lawyers have been making. Unlike in past trials, they didn't really focus on whether Trump is an insurrectionist.
If you don't fight like hell, you're not going to have a country anymore.
In both lower court rulings before today, so at trial court and appeal court, the judge found that Trump had engaged in insurrection. So one central argument from his legal team now is that the Constitution's insurrection clause just doesn't apply to him because the Constitution doesn't mention insurrectionist presidents at all.
President Trump is not covered by Section 3 because the president is not an officer of the United States, as that term is used throughout the Constitution.
So on the restricted list of jobs that insurrectionists aren't allowed to hold, you'll find this umbrella term, which is officers of the, let me make sure I get that right, officers of the United States. Trump's legal team argues that the president isn't an officer. He holds office, but he's not an officer.
And do you agree that the framers would have put such a high and significant and important office, sort of smuggled it in through that catch-all phrase?
We don't agree at all.
That's the point Trump's lawyer and Justice Ketanji Jackson seem to be referring to, that if the framers of the Constitution had wanted the president to be included, then they would have mentioned the president explicitly. You can see from the very first words of Section 3 of the 14th Amendment, senators and representatives in Congress are mentioned, electors of presidents and vice presidents are mentioned, but not the president himself. But the other main argument from Trump's legal team is that this whole question isn't for a court to decide. It's for Congress to decide.
The second reason is that Section 3 cannot be used to exclude a presidential candidate from the ballot, even if that candidate is disqualified from serving as president under Section 3, because Congress can lift that disability after the candidate is elected, but before he takes office.
This idea that Congress has the ultimate say goes back to this part of the Insurrection Clause, which reads, Congress may, by a vote of 2/3 of each house, remove such disability. So basically, if Congress says an insurrectionist is fit to be president, that's fine. And so to preempt Congress, for a state or a court to say, no, we're not even going to allow him to run for office because that's what the Constitution says, Trump's team argues that this would disenfranchise the tens of millions of voters who would have voted for Trump. And Chief Justice John Roberts sort of took this question to the extreme, asking a hypothetical about whether even in a case where someone just comes right out and says, I'm an insurrectionist, can they really still run for president?
What if somebody came into a state Secretary of State's office and said, I took the oath specified in Section 3, I participated in an insurrection, and I want to be on the ballot. Does the Secretary of State have the authority in that situation to say, no, you're disqualified?
No, the Secretary of State could not do that, because even if the candidate is an admitted insurrectionist, Section 3 still allows the candidate to run for office and even win election to office, and then see whether Congress lifts that disability after the election.
So Trump's legal team argues, specifically on this question of insurrection, because the Constitution gives Congress the power to allow an insurrectionist president to serve, you'd effectively be going against the Constitution if you stripped Congress of that power by deciding that insurrectionist presidents aren't even allowed to run in the first place. Their bottom line, you've got to let the people and Congress decide who's fit for office. Jason Murray was the lawyer taking the other side, arguing that the state of Colorado has every right to bar Trump from the Republican primary.
We are here because for the first time since the War of 1812, our nation's capital came under violent assault. For the first time in history, the attack was incited by a sitting president of the United States to disrupt the peaceful transfer of presidential power. By engaging in insurrection against the Constitution, President Trump disqualified himself from public office.
But almost immediately, the questioning from some of the justices focused on this idea that if the framers meant for insurrectionist presidential candidates to be barred from office, why hasn't it happened before?
Do you have contemporaneous examples? And by contemporaneous, I mean shortly after the adoption of the 14th Amendment, where the states disqualified national candidates.
Murray did point out one case from more than 100 years ago where a governor in Georgia refused to certify the election of a congressman. But beyond that, he said, January 6th was a pretty singular event, which brings us to what was by far the biggest issue that the Supreme Court justices seem to have with this idea that Colorado could, unilaterally decide to take Donald Trump off the ballot. And that was that this could throw the whole electoral process into a partisan, state-by-state free-for-all.
If Colorado's position is upheld, surely there will be disqualification proceedings on the other side, and some of those will succeed. Some of them will have different standards of proof. Some of them will have different rules about evidence. In very quick order, I would expect, although my predictions have never been correct, that a goodly number of states will say, whoever the Democratic candidate is, you're off the ballot, and others, for the Republican candidate, you're off the ballot, and it'll come down to just a handful of states that are going to decide the presidential election. That's a pretty daunting consequence.
Well, certainly, Your Honor, the fact that there are potential frivolous applications of a constitutional provision isn't a reason.
Well, no, hold on. I mean, you might think they're frivolous, but probably the people who are bringing them may not think they're frivolous. Insurrection is a broad term.
The core of this criticism from Justice Neil Gorsuch, and which Justice Elena Kagan also seemed to have, was, is it really state business to decide something of such national importance? Murray's argument was, well, it's not like this happens all the time.
There's a reason Section 3 has been dormant for 150 years, and it's because we haven't seen anything like January 6th since Reconstruction. Insurrection against the Constitution is something extraordinary.
It seems to me you're avoiding the question.
And it was clear that there was disagreement on just how dangerous a precedent Colorado's ruling might set, no matter how rare. But if the thrust of Trump's argument was that you can't game the electoral process by telling voters who they can and can't vote for before Congress gets to weigh in, then Murray's counter-argument was, well, just imagine if you have an election and then Congress decides, actually, the president-elect is an insurrectionist and cannot serve. What kind of chaos would that cause? Donald Trump is counting on the court ruling in his favor.
In watching the Supreme Court today, I thought it's a very beautiful process. I hope that democracy in this country will continue.
He has repeatedly reminded the justices that he appointed 3 of them, giving conservatives a majority on the bench. But if the court rules against him, there would probably be a flurry of fast challenges in other states, all seeking to do what Colorado has already done. In the end, we might see a ruling in relatively short order. Colorado's Republican primary is coming up in March, and the Supreme Court will be under pressure to clear the air.